Hi, everybody. This is a lecture on Lesson Module 2. What is justice? I've got a list here of the objectives for this lesson module, the things that I expect you guys to be able to do after you've completed Module 2. You can come back and check on that yourself a little later. All right, so let's start out with asking the question, what is justice? I'm sure everybody has their own sort of sense that justice is somehow equated with equity, what is right in a particular situation. We're going to go a little bit deeper in that and start out with like one of the earliest philosophers who had an opinion on what justice was, what law was. You probably remember studying him a little bit with the last lesson module on what is law. So we returned to Aristotle on what is justice. Um, and to Aristotle, justice meant treating equals equally and unequals unequally according to relevant differences. So you start out kind of with the assumption that everybody's treated the same, but then you have to take into consideration what are the relevant differences that might justify treating people differently. That was Aristotle's theory. The other, a little bit more modern, Karl Marx had a definition from each according to his ability to each according to his need. So Marx is looking at true equity, equality in outcome, not just opportunity. So these two different notions of justice compete with one another. And there are aspects of our justice system that incorporate both. And so I've asked you guys to consider a few scenarios um, and apply these two theories of what justice is to those scenarios and tell me kind of, do I agree with Aristotle and the way his definition of justice might apply in this scenario, or do I more agree with Marx and how his definition of justice ought to apply in this scenario? That's one of your assignments for this lesson module that you'll do as a discussion board post, so you can share your thoughts with the other students in this class. So I hope through doing that assignment, you kind of have a chance to think about what justice is, or what it ought to be, what it ought to mean, and how it ought to apply. But let's move past that. I'll let that just be something that you learn by doing, and I'll talk to you a little bit more on some different topics. Justice, how we define justice, is going to depend on the context. So when we refer to distributive justice, we're talking about how we allocate resources, finite resources. So some of the scenarios I gave you have to do with that, how we allocate resources in various situations. Another context for justice is retributive justice, which is how do we go about punishing deviance. And one of those scenarios, I think, had to do with retributive justice. But I just want you to understand that justice is contextual. So when we're defining it, you've got to put it in its context before you define it. But justice means both things. It means how we distribute our resources and how we're going to go about punishing deviance. When we talk about, especially for those of you who are criminal justice majors, you're going to focus your studies, I'm sure, throughout college on retributive justice. But political science majors are maybe looking also at distributive justice. So let's learn both of those for this class. I've got here a slide that is going to kind of be a recap, a study aid for you. I'm not going to read through it. You guys know how to read. But when you are studying for the exam, you may want to come back and look through these little bullet points and make sure you get what I'm saying here. Aristotle's conception of justice may seem to you to be more so what we have in the American system, treating everyone the same, except when we ought not to treat them the same, except when there are relevant differences that justify differential treatment of people. So that is probably more so what we apply in our culture, but it also has its own problems. It's not a perfect conception of justice. For example, who are the deciders? Who are saying what is relevant and why? What are those times when we should treat people differently? And the answer to that, of course, is your politicians. The elected leaders are the ones deciding what relevant differences are and when we ought to treat people differently. And so presumably, hopefully, our elected representatives are doing that based upon what voters ask them to do, that they're representing our wishes as to what a relevant difference is. But if you know anything about history, you know that's not always true. You know that for a period of time, African Americans didn't have a right to vote. So their voices in what should be relevant, a relevant difference or not, were not heard. Same for women. So the decider of what a relevant difference is and when people ought to be treated differently from one another, that's been kind of messed up in the past. We are getting better. But knowing that there is an element of human choice and human flaws in deciding how to apply justice, knowing that has become an area of study, like an academic study. So if our legal decisions aren't just based on applying a law to a set of facts, what else is it based on? And as humans, we all have our own subjective feelings and beliefs and values and stereotypes that affect our decision making. And so there's a field of study called legal realism that takes that extra influence, our subjective influences, and incorporates that in a study of law and justice. This is just a list here of some of those other things. What comes into play when people are deciding what a relevant difference is and when people ought to be treated differently? As I've mentioned, bias, stereotypes, political pressure and persuasion, money will come into play often. Your personal beliefs on what the outcome should be, social and political context, all of those factors are affecting the decision makers in American society, the people deciding how our laws should work and deciding what justice is in any particular situation. So you're going to have an opportunity to apply that study, that legal realism, to a U.S. Supreme Court case. That's one of your assignments in this lesson module. And I think when you look at that definition, the study of how law is actually applied in the courts day to day, how both internal and external factors other than precedent affect the outcome of a case, you'll see how that worked out in a case called Brewer versus Williams. That'll be one of your assignments. Okay, so that's all I'm going to say right now about how we define justice. Now I'm going to shift gears and I want you to think about where do we get justice from, or our notion, what is just? Where do we get that from? And you can look at this picture and probably relate to it. We were all kids once, and even very young children know when something isn't fair. So you got to admit that our idea of what is just, at least in part, is an innate principle, something all humans have at birth. We are born looking for what is fair and seeking what is fair in any situation. So coming at that, we are definitely talking about natural law theory. If it's our notion of what is just is innate, then we're dealing with natural law theory. Our notion of justice is something that exists separate from what our positive laws are, the laws that are written down. So that means that law is something more than what a government says it should be. So I want you to, we had that dichotomy, natural law versus positive law, or the natural law perspective versus the positivist perspective in lesson module 1. I want you to set aside that dichotomy now, and let's just operate in the idea of a natural law theory, because it's pretty clear that there is a human innate sense of what is fair, what is just. So where do we get that from? How do we inherit that? How do we get it? How is it in us? There's two perspectives here, a transcendentalist perspective, and then in a second, I'll show you the evolutionary perspective. The transcendental perspective is the idea that law and our notions of what is just come from some source separate from humanity. So it begins somewhere outside of us. Our sense of justice exists separate from us. And it is a timeless, universal concept. That means what is just is universal and has existed across all time, across all cultures, everywhere. And as we grow and our brains develop and as we learn, we come to a better understanding of what justice is, or what is just or fair in any particular situation. Then our positive laws, the laws that governments write and enforce, have to adapt to our learning of what is just. So we learn by, you think about Plato and the theory of forms. We learn what is just through our studying and our debating and discussing, and kind of through conversation and dialogue, coming to better understand what is just. And then we change our laws in order to fit our new notions of what is just. This perspective is kind of an application of this is a Latin phrase, jus cogens, don't know how to pronounce it, but it means higher law. So if law is universal, or justice is universal and timeless, that means there's a law that governs all of us across all countries, all around the world. It is a justification for having an international law, something that applies regardless of what country you live in. There is no American law or German law or Russian law. There's just law, justice. It's universal. That's jus cogens. So that fits in the transcendental perspective. There's something that applies to everybody, regardless of where or when you live. There can be good and bad consequences of this theory. Good consequences are the way that we have changed our government systems in order to support equity and fairness. Something we're going to talk about a little bit more later, just in this lecture. Our Declaration of Independence incorporates this transcendental perspective of nature's laws, what is right, what is wrong, what a government ought to be. So that's a good way that we've applied this transcendental perspective. But it can also be a bad thing if law comes from a separate source. What is that source? If you're a religious person, it's God. If you're not, it could be nature. But there was a time when the dominant culture was that God was the source of law and justice, and God passed that ability to know what is just on to kings. It's known as the divine right of kings. We're going to come back to that in a little bit, but that would be sort of the bad way of looking at a transcendental source of justice, because it can be manipulated. All right, so that's a transcendental perspective. Then we come to the evolutionary perspective that I mentioned earlier. So if transcendental says that our notion of justice exists separate from humanity, the evolutionary perspective says that no, it begins with human choice, that what we know as just comes from the choices that we make. And this, if you think about evolution, evolution is how humans' physical bodies changed and adapted in order to promote survival. Now you apply that to our understanding of justice. And you say, okay, we are choosing laws that promote our survival. So here's how that kind of works. Everybody has a innate sense of something called moral outrage. When we see behavior that exploits humans, we are naturally outraged. We get angry at it. We want to stop it. We want to retaliate against it and punish the person who's doing the exploiting. And that outrage comes from the fact that the behavior decreases the likelihood of success, of survival. So we are outraged at things that would result in destruction of the human race. And we seek things that promote the human race and its survival and perpetuation. So that's the evolutionary perspective. We make choices based upon what results in the survival of the human race. And we do that through this notion of outrage at exploitation and pleasure that comes from punishing or retaliating against exploitive behavior. Now, in one big sense, this moral outrage is universal, and there are definitely laws that all cultures across space and time have always had. But then there are also at a smaller sort of micro level, some cultures, and unique to that culture, are outraged at certain behaviors that may not outrage another culture. An example of this, I'm not sure if this is given in your textbook or not, but one that I thought of is in the nation of India, at least for a time, moral outrage came when we witnessed the killing of cows. So cows are held in high regard, held in esteem according to their culture. And so they would be morally outraged to see cows be harmed. And that's unique to their culture. So at some level, then, even the evolutionary perspective is sort of local and unique to a culture. But then there are other aspects of moral outrage that are universal. So let's look at that. An application of that came with the definition of something called natural crime by this guy named Garofalo. He was a criminologist studying, these law reform and how to make the law more just. And he was looking at the criminal code in many Western European cultures, and he thought that it was wrong to just come at this from a positive perspective, that a crime is a crime because government defines it as a crime and enforces their laws. He thought that no, crime really has to be defined by what is universally condemned, what is naturally wrong, what all people think are wrong. So he categorized them. They're mala in se crimes. Mala in se translates bad in and of itself, bad in itself. So what crimes are universally condemned? They are mala in se offenses. You would think of murder, rape, theft. All cultures across all time punish that behavior. So coming at that from an evolutionary perspective, those types of crimes work against survival of the human race. They're exploitive. We feel a sense of outrage against them, so we retaliate against that behavior. That's a mala in se crime. All other laws are known as mala prohibita laws. They are crimes because our government wants them to be considered a crime. Our government at our time. So these are the crimes that are defined in a very culturally specific, time-specific way. An example that you might think of is maybe prostitution or sodomy laws. Those types of laws aren't universally condemned, but some cultures at certain times have punished them. So mala prohibita are cultural specific, whereas mala in se crimes are not. They are universal. Right, so that's just an application of where our laws, our sense of justice comes from. We can all agree that there is some innate sense of what is fair. And so that puts us in a study of natural law. And then within that study of natural law, we get two perspectives, the transcendental perspective and the evolutionary perspective. And Garofalo is applying that evolutionary perspective by recognizing that there are certain crimes that are counter to the survival of the human race. Therefore, we all humans experience moral outrage against them and punish them. Those are considered mala in se crimes. All others are mala prohibitive crimes. And that is a common way that our American justice system defines crime. And we'll see that more in a later learning module. Okay, so shifting gears just a little bit. Now we're going to look at how justice came to be part of our legal system. And there's more than one sort of route that justice took to get into our current modern American legal system. And I'm going to start with this one on the development of equity or incorporation of equity. So first we define equity. So equity means fairness, okay? What ought to be the outcome in any situation. Separate that from positive laws. So laws that a government or a king writes down and enforces. Those are positive laws. For a time, that is all that existed in Western European society. What the king said was the right thing to do became the law. And then notions of common law sort of grew up, what communities traditionally did. They established precedents of how we interact with one another, how we do business with one another, and there came to be a development of common law. So you had sort of the king's law and then the common law, but it was always these principles that were written down and applied predictably in every situation. So it provided brought order into chaos and helped societies emerge and economies develop, and people are willing to take risks because they know the outcome. So you build this predictability when you apply a written set of laws in every situation. Here's the law, we apply it to the facts, here's the outcome. That's the application of positive law. And it's good because it gives us predictability. We know what to expect in any sort of business or social interaction. But sometimes the application of a legal principle doesn't work out to be a just or fair, equitable outcome. So what do you do in those situations when the law doesn't achieve justice? Well, that's where equity comes into play. And so the way it worked historically is if two parties were mad at each other and they had a dispute and they go to the king or the king's court and they say, oh, he's wronged me. What's the just outcome? King applies the law, or the king's appointee applies the law, and the outcome is given, but it's not fair. So the application of the law was not fair. Then the parties could go to the king's chancellor, and the king's chancellor would provide equity. He would say, okay, I get maybe the law that is available to us, those written laws don't work here. I'm just going to make a ruling that I think is fair in this situation. And the parties walk away with their equitable decision. All right, so that's good. In that specific situation, it worked out to be fair. But that lacks predictability because you've got one person who is just deciding what they think is the fair outcome. They're not applying any legal precedent or written rule. It's just what they think is the fair outcome. So it is good. It achieved fairness in that situation, but it is bad because it lacks the predictability of the common law system. So those two systems kind of ran parallel to one another for a time. You could go to a court of law or you could go to a court of equity. You go to the king's court or you can go to the chancellor's. But over time, those two systems merged with one another so that courts of law would apply equitable principles, or you might go to the chancery court, the chancellors or chancery court, and he might say, no, I'm going to apply the legal principle in this situation because it actually provides the right outcome. And so that's called cross-pollination. The two separate, the legal common law system and the equity system, merged together and started doing the same thing as the others were doing, and the kind of came and blended together. And so now if you walk into an American court system, you obviously will have plenty of legal precedent that could apply to your dispute, but you will also have the opportunity to ask the court to apply equity in your situation and give a just outcome. And there are precedents of the application of equitable principles, the same way there are precedents of the application of legal precedent or legal decisions. So they're together now. You can have the application of a law or you could have application of equitable principles. The same court can do both now. Some states, I think like Mississippi, for example, there are separate equity courts called chancery courts, but they tend to be courts that specialize in probate and family law, whereas your typical civil criminal courts are just courts of law. There's a case in that's discussed in your textbook, Riggs versus Palmer, and I encourage you to give that a good read. It's a pretty interesting case about a nephew who kills his uncle before his uncle has a chance to change the will and write him out of the will. And so he gets convicted of murdering his uncle, and then still insists on having the will followed so that he inherits all this money. So he's inheriting money from the man he killed, which is obviously not equitable. And so the court's kind of in a quandary. It's got all these legal precedents that say, the will controls whatever the decedent wrote in the will is what will happen. And if this murderer nephew here is in the will, the murderer nephew gets to inherit regardless of the fact that he killed his uncle. But then other judges on the court said, no, that's not fair. We're going to apply equity here. And we don't let the guy inherit. And that decision in and of itself, the Riggs versus Palmer decision, became a precedent. And the rule that you can't inherit from your murder victim became a legal principle. It was actually codified. They're called Slayer statutes. They're in a lot of state codes now. Murderers cannot inherit from their victim. Anyway, it's an interesting, fun little case to read. It's not long. You can look it up and read it. All right, so the next way that our laws our justice became more a part of our laws happened through the Enlightenment. So we look at that for just a minute. And we start way back in history, before the Enlightenment. The rule of man, that's where our Western European culture kind of started out with something called the divine right of kings. And this is the idea that our transcendent source of all that is right and good and just, God, would sort of endow a king with the ability to discern what is right and wrong, the ability to know what is just, and whatever that king said was the law. So that is an application of actually Max Weber's substantive irrationality decision-making, because you have a non-legal scholar, just a king, deciding things on a case-by-case basis. Whatever the king thought was the right thing to do was what was done. The king was the law. That's the rule of man, or the divine right of kings. And that governed most kingdoms for many years. But during the Enlightenment, we have something new emerge called the rule of law, where the law is king. That's the reverse, right? Not the king is the law. No, the law is king. Lex Rex, I think is what the Latin phrase for that means. Okay, so how did that happen? This is where you probably should have, there's a video assignment on the Magna Carta that tells the story of how this worked out. 1215, King John, his barons got angry with him. He was a little bit too greedy. So they held him to account and required him to sign a document that recognized what they believed always was true, that men have certain rights to fairness, fair treatment. And they made a list of what those rights were, the things the king could not do. So it's a list of sort of principles. The king shall not do this. The king shall not do that. That's what the Magna Carta is. It's a lot of shall nots. And they forced King John to sign that Magna Carta to try to hold him accountable and say, you are not above at least some law. There's some amount of laws that even you cannot contradict. You, king, are subject to some laws. And that idea kind of waxed and waned for a few hundred years, but eventually it became more and more a part of the justice system, the legal system in Western Europe. And that's thanks to the efforts of some legal scholars. I believe in the video they tell you about Sir Edward Coke, who took the Magna Carta and said, you know what, this should be part of the English common law. And he wrote I guess it's an essay, Petition of Right. I think Parliament asked him to write it down, his ideas down, and he did. And he argued that there are certain principles, certain rules of fairness that just apply to everyone, even the king. An example that you might recognize is that we should have a right to a trial. Before we can be deprived of our life, liberty, or property, we should get a fair trial. That was something that emerged with Sir Edward Coke. And he wrote down, he's known as the father of due process because he was the first person to try to incorporate these principles of fairness into the English common law system. Another one that you should remember, just his last name, Beccaria. He was an Italian criminologist, and he kind of took it a little step further and gave some additional rules that he thought should be part of the criminal laws in Western European culture. The right to confront one's accusers, the right to be informed of the charges brought against you, the right to receive a speedy trial before an impartial judge, proportionality in punishment. He opposed the death penalty. So these are just continued efforts to take certain principles of fairness and make them part of a legal system that not even the king could ignore. Even the king had to follow these principles, these rules of fairness. So that's known as the rule of law and due process. So you've got those two video assignments in this module, and the scholars will do a much better job than I have in explaining how we shifted from the rule of man to the rule of law and the way due process came to be part of the Western European system. But moving forward in time, we get to the founding of our country, and those English common law due process principles are brought into the Americas with the colonists, and they were applied into the formation of our first national government. So here you've got the picture of the Constitution being debated there in the Convention Hall in Philadelphia. These men had studied the Enlightenment principles of their era, and when they sat down to form our national government, they decided to take those principles and make them part of our legal system, make them part of our government. Placing limits on the power of government was really what they were trying to do. And they were taking the rules that you would see, some in the Magna Carta, some in English common law system, they took those and they wrote them down. And that's the important thing. In order for due process and the rule of law to really work, you got to have certain things happen. And this is how it works, how it has worked in America. You start out with having a nation that recognizes the supremacy of law. There are certain principles of fairness that we as a nation will recognize and uphold. Okay, so you start out with that. Then you got to write it down. And that was what they did in the U.S. Constitution. They took those principles that are valued, principles of fairness, and they wrote them and made them part of our Constitution. Government shall not do these things. There are certain rights human beings have, and that government cannot trample on those rights. The power of the government is limited by the Constitution. And then now you got it written down. Now you got to have some procedures to hold the government accountable. So the Constitution doesn't mean anything if you don't enforce it. And that's what we're talking here with this third bullet point. We've got to enforce our Constitution. We got to hold the government to task and make sure that these principles are upheld, that they are a reality. And that's what we do in our American legal system. Here's an example. Let's see. There you go. So that's an image of something called lettre de cachet, if I pronounce it correct, French there. This is the old time, long ago warrant. We have search and seizure warrants today. This is the search and seizure warrant of back then, way back then. Think like Louis XIV, okay? Long time ago. That's all you would need. The king signs a general warrant, and that would give you, the holder of the warrant, the power to imprison someone, to go and take them from their home and put them in a dungeon and hold them there indefinitely. They may never know who's accusing them of something. They'll never see an attorney. They may never have a judge or jury decide the outcome of the situation. So they could rot in a jail unless they had some sort of advocates trying to plead the king for their release. So that's what justice was in the criminal justice systems long ago. Now we have this much more formal, more detailed warrant, modern day arrest warrant. Nobody can be deprived of their life, liberty, or property without probable cause. And a judge is going to analyze the integrity of the accusation, and the person who is taken to jail will get a speedy trial. They'll see a judge, they'll have a jury, they'll have a lawyer, they can challenge the evidence against them. This is just sort of a juxtaposition of justice systems before equity and the Enlightenment came to be part of it, and what we have today, where you see equity and you see the rule of law that offers us fairness in the outcomes of our criminal justice system. The last thing for this module, and where you want to really focus your attention, is on looking at two different models of the criminal justice system that were offered by a professor named Herbert Packer. He is not giving us really a definition of justice. What he has given is models for analysis of our justice system. These are like the mirrors that you can hold the justice system up to and say, okay, we like this. This is a good system. And he's given us two mirrors. So we can have a crime control model and say, all right, how well does our justice system measure up to this model, this crime control model? Or you can come at it from the due process mirror and say, how does our justice system measure up when you stack it against these principles? And that kind of sets up two ideal types. And probably most people are going to be somewhere in the middle. between a crime control model and a due process model, or you may lean kind of one way or the other. It's just an individual choice. So he's not saying one of these is right and one of these is wrong. He's just saying, here's a way of looking at our criminal justice system, analyzing it, and deciding if it is what we want it to be, what it ought to be. So the crime control model that he offers says that the goal of our criminal justice system is safety. Community protection is paramount. So our justice system, how well is it giving us safety? That's how we measure it. And the crime control, well, looks like I've got to go back and forth. Okay, so the due process system does it a little differently. They look at the integrity of our system. Is our system fair? That is the paramount concern. Are their rights being protected? Their due process rights, are they being protected? And if our system is doing that, then it's good. So that's the mirror you hold our system up to, is how well it protects individual rights. And if you're looking at it from the crime control, your perspective, you're looking at, are we measuring up? And that's determined by how safe we are. What are the crime rates in our community? That's the most important thing. That's crime control versus how well we're upholding individual rights. So if you look at that little scale, I want you to see and pretend on one side of the scale are individual rights, and on the other side of the scale is public safety. Our justice system seeks to balance both of those two goals. That's how it works out in reality. Now we'll go in a little bit more with the crime control model. If public safety is your paramount concern, then you've got to put a lot of faith in the police and the prosecutors and assume that what they are doing, they're doing it right. They know they're getting it right. And so we don't need to have any obstacles in their path. We trust them to only put the factually guilty people in jail, and the factually innocent people will never go to jail because our system works efficiently and we get it done correctly. We don't worry about, not that we're not completely ignoring individual rights, but we just trust the system that individual rights are not being trampled. On the due process side, that trust is missing somewhat. They are going, that type of system puts a lot of obstacles in the path of prosecution to ensure that individual rights are protected. And you can look at it like hurdles. Prosecutors have to jump over certain hurdles before they can take away someone's freedom. So there's less trust in the justice system from that model. Back to crime control, I already mentioned, we trust the system that innocent people are screened out. Individual rights are not being interfered with, and the people who are convicted are guilty. They are factually guilty. Whereas in the due process, the factually guilty might go free. If the system tramples on individual rights, then that may result in, or at least there's a risk that factually guilty people may go free. Because, and you would hear the criticism would be, oh, he got off on a technicality. Okay. So what they're referring to when they say a technicality is not really a technicality. The person is not losing their freedom because the system didn't work right. The system didn't protect those individuals' rights. And in order to have a justice system with any integrity at all, those written down in our Constitution, individual rights have to be enforced, even at the risk that sometimes a factually guilty person may go free. Okay, so if you want to figure out, am I more of a crime control person or am I more a due process sort of person? Ask yourself this question: which is worse, that a factually guilty person goes free, or a factually innocent person spends the rest of his life in jail for a crime he didn't commit? Which of those is worse in your book? So if in your book, it's worse for a factually guilty person to go free, then you're on the crime control side of things. But if to you, it's worse to see an innocent person go to jail, then you're on the due process side. But again, our system incorporates both of these models. They set up ideals. We are not an ideal system. So there's messed up things in our justice system. You would agree with that. I assume you would agree with that. We have a little of both here, and we're working towards both goals. Community safety and the protection of individual rights are our dual goals. And so as we study crime and crime control in this class, you're going to start to see our laws are an effort to balance these two goals. Okay. So one of your assignments for this module is to read a particular U.S. Supreme Court decision called Brewer versus Williams. And when you read it, I've given you a copy of it. I want you to look at how the majority of the justices, so this is a split decision where you had a group of Supreme Court justices, the majority of them made a decision, and then a few of the justices did not agree with the majority, and they wrote their own sort of reasons out in a dissenting opinion and explained why they think the outcome should be different. So you look and you compare the majority decision with the dissenting decision and say, okay, which one of these fits the due process model and which one of these fits the crime control model? And it'll be pretty clear. You're not going to have trouble working that out. But I want you to explain why that is the case. Why is the dissent on applying this model? Why is the majority applying this model? And then go back to that idea of legal realism, because you got 9 justices and they're looking at the same set of facts. They are applying the same legal precedents, and yet they arrive at 2 different outcomes. Why is that? How could that have happened were it not for the interplay of subjective factors? They wanted a different outcome. And so they construe the law in such a way that it will achieve their desired outcome. So what's affecting them? I want you to think about that. Think about the time period when the case was decided. Think about the facts of the case. Why do you have a group of really smart people come out with one outcome and then another group of really smart people come out with a different outcome? What is working in the system for this to be the result? So it's kind of a little essay I want you to write based on this case. Not a long essay. Don't get worked up over that. It's just sort of an analysis, a case study for you to try to apply these concepts. If you have any questions with anything I've gone over or any of the assignments, please send me an email. I'm always here to help you out with that. And y'all have a good day.